Sawubona Jacinta.
Hallo Kali, hoe gaan dit?
Ag, dit gaan goed man, baie dankie. Sia kwamukela AfriForum.
Oh hey, baie
Yes.
dankie. Ek is welkom na AfriForum.
Ja man, baie dankie vir die lekker gesprek. Ek hoop jy kom weer by ons kuier. En
Definitely sizobuya sizela again. Sizokhuluma izinto that are going to make the country better.
Most definitely. Ons gaan nou braai.
Aye, let's go eat some meat.
Hi everyone, today we've just had a very productive meeting with AfriForum. As you know, there's a lot of issues that they tackle that have to do with dealing with community issues. They've got litigation, prosecution, they're able to help people in different areas, and that is ideally the type of movement that we want to be. And we want to be able to take pride in who we are and get things done and do them correctly without compromising our people and making sure that we spend their money correctly where they need us to spend it correctly and, you know, deliver what government has failed to do. So for us, it's very exciting because we've found a lot of areas of collaboration. We've found areas where obviously we can't agree on everything, but what we agree on is way more than things that we might not even agree on, which we don't even know what those issues are yet. But we're here to learn from each other. We're here to teach each other. We're here to also make sure that the people of South Africa are able to come together across different racial lines and across different traditions and find each other, you know, after all the years of being separated by race and skin color, and find ways of making the country work, because that's what we all want. We want roads, we want schools, we want water, we want buildings, we want a country that is lawful and where everyone can live in peace and in safety. And that's what we're here for ideally, and we're hoping that today's session is the beginning of a lot of things that are going to be going right for South Africans, and they don't need political parties to do that.
First of all, mina sibangama South Africans yini lebenza bengahlanganyeli nathi njengoba simasha la. Sifuna ukuthi phekwa lokho iAfriForum isitshela ukuthi njengoba bekwazi bona ukuba nama university nani na bano private prosecutor banamaphoyisa abo banezinto zabo yini thina sihlulayo sisikwenze lokho. Sandla lesibuka belungu sibazonda yini kangaka indaba thina singabi nento yethu sizenzela yona. Mawukuthi kufanele siyofunda kubona belungu siyofunda. Mawukuthi kufanele sifunde ukuthi uba kanjani ne-university yakho ethi wena ekhuluma ulimi lakho lesizulu siyofunda lokho. Ngoba yikho into erongo ukuthi nathi sithi ne-university yamaZulu. Ne-university yamaXhosa, yamaPedi, yamaTswana, yamaTsonga, wonke umuntu angabe ne-university yakhe. Kanjalo thina fanele masibuka belungu sibe nenzondo yokuthi benze into yabo. Nathi sinethu into esingayenza. Sihlulwa yini? Sihlulwa ukuthi asinabo abaholi. Magya! Abaholi benu. Nazo. Abaholi benu bathanda imali.
We are not xenophobic. We are here to welcome our brothers and sisters from the SADC region that is all joining us here today. Because we are talking about 16 different destinations within the region. And when I heard now that even here in the restaurant, they're going to have the different foods from Tanzania, from all over. And we must direct the delegates also to tell them that they can come and say they're on their own food here at this restaurant.
Guys, I'm going to keep this short and sweet. It makes no sense to go to the person who's oppressed you and taken your land to go look for leadership advice and tips. It just makes no sense. Even in a household, if you grew up in an abusive home, it makes no sense to go back to your abuser. In 1912, there was the Land Act where our land was taken from us and given to mostly the Afrikaner community. So the land that they're living off right now is inherited from our loss. So it makes no sense. It makes no sense to go to the people who created a system called apartheid that showed you how much they hate you. It makes no sense for you to go to them for leadership. To be true, a truly African and South African community, we need a leadership that is African, because our institutions and our traditional systems are more humane and more inclusive. And lastly, the conversations you should be having with AfriForum is, how are they developing the communities around them? Which sections of their land are they sharing with their African workers? What do they intend to do about the unfair disposition of land? Those are the conversations we should be having with AfriForum, not looking for advice from people who took from us.
We need to look at the officer that we employ in these law enforcement agencies that we have. Are we recruiting a gangster? We have generals, perhaps, that are currently in the police, that grew up as members of the gangs until they joined the police and they finished the college and they got promoted throughout. And then you trust that the generals are going to come with a solution, and yet they are members of the gangs themselves. So what are the security measures we put in place to make sure that we prevent such from happening? And that's not only within the SCPS, it's across the entire law enforcement. Courts, Honorable Chair, the courts, I will look at them as involving three different officers there of the court. One of them are the lawyers. We have a legal practice council that exists in the country that regulates how the lawyers must behave. We cannot give you the names, but we know the names of the lawyers that are paid. Someone presented here that the lawyers, I think it was a brigadier, who said the lawyers come to court and pay the bail for the person arrested without even that person affording the bail. They know that they are paying on behalf of, they're paying this one, they're going to collect it from the boss gang who's somewhere else. That's how the lawyers survive these days.
Thank you. Could I then, on your main case, which is the question you pose for the court to answer is it a defense to spoliation that you have statutory authorizations? Is that correct?
Yes.
Now, there is a case of the Supreme Court of Appeal called Street Pole Ads versus eThekwini Municipality. Are you familiar with that case?
No.
All right. It's reported, perhaps you can deal with it after the adjournment. It's reported in 2008, Volume 5, SA 290. It's a judgment by Justice Cameron. And he says that in a spoliation case, if an applicant goes further than the traditional grounds of spoliation and relies on the substantive right of possession, such as title to ownership or contract, then it is permissible for a respondent to enter the merits of the right to possess. And in that case, he said that it was permissible because what the municipality had done was not only to cite a spoliation, but also to go beyond the spoliation and to ask for an interdict. It struck me that that case is analogous to what we are dealing with here, which would then mean that Justice Makgoba was not incorrect necessarily in paragraph 53 of the judgment when he found that it was permissible for him to look at the right of possession of your client and the right of possession of Nkwe, both of which are competing statutory authorizations. So I wonder if you have submissions to make on that point.
Yes, and the submissions are, our case was never that so the case of MPM was that it relied on its occupation and a spoliation application. That was its case. The interdict case was simply, first it was in the alternative, and second it was simply a case of you've breached a statutory requirement, and if you've breached that, we're entitled to the interdict. So the case you refer to, the judgment by Cameron J.A., is not analogous because it's not an analogous situation. MPM didn't rely, for example, on a contract with Nkwe or anything of that nature. It simply said, well, we were in possession. Of course, The context of its possession is that it held a mining right, and it said, as a result of that mining right, we took possession and we were there. We occupied it since 2002, the property.
Well, isn't that the problem? That the possession is not a common law possession, it's a mining right possession.
No, but it doesn't matter what the nature of the possession is. In fact, it can even be illegal possession. If you're in possession, you're entitled to a spoliation application. So it doesn't really matter.
Yes. And the pleadings in this case also rely on the mining right as creating the possession.
No. So obviously, it's a,
Yes, could we? You're saying that they don't?
No, I'm saying this. Obviously, the context is not irrelevant. And what MPM did was it said, we're in possession. And we got there, we're in possession because this is how we got here. We got here through a mining right. And we're in possession, and we have been in possession since 2002. Well, assume
but 2002 is just the start of the mining right.
Yes, but it continues since then. It stays in possession.
Well, that's the problem I have with the case. The way it's pleaded, this is the point, it's not a new point, it's the point that Justice Savage put to you. The way the case is pleaded is that what was spoliated was the mining right itself.
No.
Well, perhaps you can help me to understand the pleadings better. If you go to the founding affidavit, which is volume 1. So, paragraph 3.10 of the founding affidavit. And then you go to the summary of the case, paragraph 4 of the founding affidavit. And then you go to paragraph 5.7 of the founding affidavit. And then paragraph 5.11 of the founding affidavit. And paragraph 10.2.1 of the founding affidavit. All of those paragraphs suggest that the complaint about what is spoliated is the mining right itself. So that's why I'm saying maybe you can help me to understand these pleadings better.
Well, so I mean, even a right can be spoliated. We know this. An incorporeal can be spoliated.
I accept that fully, but I'm simply trying to understand that your client's complaint was that what was spoliated was that right, but as a matter of law, it's correct that a right can be spoliated.
Yes.
Yes.
Yes. But its case is that it was in undisturbed occupation, and Inquire took occupation of its mining area without its consent. I mean, that is the case. I mean, if those are the facts, then we say that's good enough for spoliation.
Yes. Could I then ask you a different point? Perhaps you can come back on this. I understand that. A different question. On the remedy itself, what we have with, even before this new application came, we already have enough evidence that the area basically had been built up by Inquire. Is your case that the constitutional requirement of justice and equity doesn't apply to spoliation?
No, it doesn't.
I mean, I also struggle with that principle. Why would a spoliation not be tempered by the requirements of justice and equity, which are constitutional requirements?
Well, we set out in our heads why it wouldn't be, because we refer you to, is it the, let's find it in my head, it's the case of, it's the case in the SCA, sorry, no, in the Constitutional Court, I think. Let's find that. Yes, here we are. We say in our heads at paragraph So from page 15 onwards, courts can make just and remedial orders to resolve disputes over constitutional rights that involve social policy problems. And they may do so in a way that promotes the parties themselves. That's the worst called Ermelo case. There, the Constitutional Court says why it does this. So they may do so in a way that promotes the parties themselves offering solutions, and in a way that is practical through structural interdicts or supervisory orders. This approach was confirmed in later judgments, and we give you the judgment at footnote 25, I think. Now, we say that approach can't apply to a spoliation application because Ngukumba provides a remedy that stops self-help. I mean, that's the remedy to stop self-help. There isn't a more just and equitable way of stopping self-help other than ordering restoration. I mean, how else do you stop self-help? Because, of course, what you've got to do then is the parties have got to go back, as it were, to the underlying situation where either their rights are resolved in court or by way of arbitration or by way of agreement, whatever. But until that, I mean, that can't happen at this stage. We can't get into a debate about how best do we sort of resolve this problem. That's not the purpose of spoliation or spoliation remedies. Its purpose is to resolve one-on-one problem only and restore ante omnia, so that the parties can then pursue whatever remedies they have in law.
Thank you, Chief Justice.
Sorry, forgive me. I was going to say that I think I've overstepped my time. But